And so, you know, the idea of these encyclopedias of various sets, whether it's the Americano or the Funkin' Wagnall or the Groliers or whatever, they're all competing. They're competing for a certain niche market. And so, knowing that they're in competition one with another, they seek out the best writers oftentimes for these articles. And then, of course, the editorial staff comes in and they make sure that you don't say something that would conflict, you know, their sponsorship or the people that were, you know, financing this undertaking. But generally speaking, they seek out different writers, and they write the articles in different ways to present new information that you can't get someplace else. And so I've got 7 sets of encyclopedias here in my house, and so I go through these various things, and from each one you can take a little, borrow a little. You run your antennas of discernment all the way up. You know you're getting hosed 9 times out of 10, but you're trying to pull together parts and pieces. So this one is a real good statement. All right, here we go. And I'll go back to the, I'll go over to the Black's Law Dictionary in a minute. We'll get to some of the definitions of some of these other trusts that are out there. Although these are pretty good definitions in this encyclopedia. Inexpensive set, accessible to John Q. Average Man, maybe somebody that understood what the trivium and quadrivium were. But here, there are 4 essential elements, and I talked about them yesterday. Repetition sometimes is the mother of learning. There are 4 essential elements of a valid trust. 1, a designated beneficiary. In order to create a more perfect union, you know, blah, blah, blah. Kind of hard to figure these things out. But there needs to be a designated beneficiary. Who's going to benefit by the trust? And then, 2, a designated trustee. Who must not be the beneficiary? Can't be the same. One and the same. At least not by this definition. 3, a fund or other property sufficiently designated or identified to enable title thereto to pass to the trustee. There's got to be something in there. 4, the actual delivery of the fund or other property or of a legal assignment thereof to the trustee with the intention of passing legal title thereto to him as trustee. You've heard about people, well, get your you know, your property all into a trust so that you can't be attached. You know, somebody's coming after you, breathing down your neck with lawsuits or criminal stuff, and you've got everything stuck away nicely in trusts. You might have to do a little bit of time. When you come out, you can still be the trustee. You can still be the beneficiary of your trust because you've given legal title to someone else. Of course, for we the people, you know, we've given legal title to our automobiles and everything else to the state or the Fed. The paramount duty of a trustee is to carry out the directions in the instrument creating the trust. Man, if you don't know what the directions were when we created this trust, the whorehouse on the Potomac, you don't know what the directions were, you're screwed. To put it as crudely as I know how to do. All right? They are, okay. So the paramount duty of a trustee is to carry out the directions in the instrument creating the trust, except so far as they are contrary to good morals or in conflict with some positive law. Talked about that before. Conflict with morals. What do we do in a world that's become immoral? Why, then you just get Bertie Madoff, you know, Lloyd Blankfein and company, or Barry the Usurper, or Jorge Bush, or in conflict with some positive law. Those would be the statutes. Or except so far as some statute has given him a discretion. A trustee is bound to exercise due diligence and care, cannot delegate his powers, some due diligence and care, and cannot delegate his powers and duties either to a stranger, like China or Israel, or co-trustee, unless authorized by the instrument creating the trust. So you've got to read the fine print. Or unless he is morally obligated to do so from necessity, perhaps the incompetence of or the bankruptcy of the trustee. Further, a trustee is not permitted to use the trust property for his own personal advantage. They go into government, you know, ostensibly, and set aside all of their wealth, right? Put all of their wealth in trusts. And they serve in government because it's not supposed to accrue to them for their own advantage. Of course, then they go out on the speaking circuit and they rake in the big bucks just for saying howdy. A trustee is not permitted to use the trust property for his own personal advantage or do any act inconsistent with the interest of the beneficiary. The term trust is also used widely in the sense of a monopoly, a contract, a combination, a confederation, Articles of Confederation, or understanding expressed or implied between two or more persons to control the price of a commodity, or between two or more colonies to control commerce between them and to maintain peace between the colonies, or service for the benefit of the parties thereto and to the injury of the public and tending to create a monopoly is such a trust. And it goes on, monopolies are regulated to a large extent by legislation such as the Federal Antitrust Act, the Sherman Antitrust Act, and the Clayton Act. You see, so you're reading an encyclopedia, and then you come across and you get these three. Now, typically, in an encyclopedia, you can go and find the articles on the Federal Antitrust Act, the Sherman Antitrust Act, and the Clayton Act. And, of course, they'll be listed alphabetically either in the index or in the pages of the volumes. But you can also jump up on the Internet and do the same thing by searching them out. Putting them in your browser. The federal government chiefly receives its authority to regulate monopolies under its federal constitutional grant of power, quote, to regulate commerce with foreign nations and among the several states and with the Indian tribes. If you wanted to know where the authority comes from in the Constitution, there you go. The validity of state antitrust statutes has been most frequently upheld by virtue of a proper exercise of its police power. A little bit more. Among the personal relations of a fiduciary character are found those concerning attorney and client, bailor and bailee, executor and heir in wills, broker and client, factor and client, guardian and ward, be careful with that one, start talking about parents and child, and the commercial trustee and client in investment trusts. In general, a trust might be likened to a corporation. The trustees take the place of the directors in a corporation. The beneficiaries occupy the nearly relative position of the stockholders. The declaration or agreement, see, we've got a confederation in here, now we've got a declaration in here, we've got agreements in here, we've got the donors in here, the creators, the settlers, the trusters, the founders, all these words pointing right straight to the founding of this country. The declaration or agreement of trust supplants the certificate or the incorporation or the charter. Of course, in all the charters, all the colonies were chartered, weren't they? The Queen. And the Queens and the Queens and the Pope. And the churches. So now let's jump over here and pick this up with this, making the decision. Now, let's do this one. Dillevue and Howard, Principles of Business Law, making the decision. The business with substantial capitalization will be a corporation for the reasons previously noted. If the business is to be owned and operated by relatively few persons, the decisions as to the form of organization involves a consideration of factors previously discussed. The most significant are taxation, liability, control, continuity, and legal capacity. So we're moving a little bit here from from the trust proper to making a decision between corporations and trusts. How closely these are tied together. So in the video, Corporation Nation, on the one hand, we've got this corporations. Prior, and perhaps higher, we've got the idea of these trusts that were originally established. So we have these trusts, and then inside the trust we run as corporations. And again, the businesses with substantial capitalization will be a corporation. So the more money is involved here, the more land, labor, and capital is involved in here, the greater the likelihood is that you're going to wind up dealing with a corporation, or we might just call it the commercial venue. The commercial venue. So there's more here. Choosing the form of organizations and so on and so forth. We're going to drop out of that and jump back over to here. The objects of the trusteeship are various. This comes out of Salmond on Jurisprudence, the 12th edition, again. But we go here, the objects of trusteeships are various, shared this yesterday. It is possible, however, for the law to take one step further in the same direction. This step it has taken and has attained to the conception of an incorporation. And we're going to move a little bit away from trust, look backwards. This step it has taken. This may be regarded from one point of view as merely a development of the conception of trusteeship. So the development of a corporation, the creation of a corporation, is just one step removed from this trusteeship. They all work together. It's a long chain of abuses.